Hello everyone. In this presentation, we will examine the relevancy of statements made under special circumstances under sections 34 to 39. The general rule is that self-serving statements which are designed to serve, advance or promote the interests of persons making them are not allowed to be proved, as such admissions encourage persons to fabricate evidence to serve their purpose. But section 34 makes an exception to the rule and provides for admissibility of entries made by a person himself in his books of accounts regularly kept in the course of business. Under section 34, it is only the particular entries that are relevant to the matter before the court that are admissible. These entries are contained in a book of accounts which naturally contains a series of different entries including the relevant entries. These accounting books have to be regularly kept in the course of business. Such statements are only relevant in the sense that the court may look into them, but such statements shall not alone be sufficient evidence to charge any person with liability. The assumption of section 34 is that there is high degree of improbability of untruth in statements that satisfy the above condition. As the account books are kept by persons who are employees in an establishment and are responsible to a supervisor, the chances of accuracy and correction of mistakes are very high. Section 34 applies only to books of accounts and not to stray papers. Loose sheets of papers cannot be called book. However, there is no particular form of book of accounts generally prescribed. It has to be regularly kept, which does not mean correctly kept, nor does it necessarily mean kept on an hour-to-hour or day-to-day basis as and when the transaction takes place. The fact that there are mistakes or incorrect entries does not affect the relevancy of the entries, though it might affect their reliability. Therefore, when A sues B for a sum of money, it is open to him to put his accounts books in evidence provided they are regularly kept in the course of business and show by reference to them that the amount claimed by him is debited against B. The entry made by A is in his own accounts book and it is in his own favor. It is a piece of evidence which the court may take into consideration for the purpose of determining whether the amount referred to therein was in fact paid by A to B. The entry by itself is of no help to A in his claim against B, but it can be considered by the court along with the evidence of A for drawing the conclusion that the amount was paid by A to B. The difference between section 32(2) and 34 is that if the person making the entry is not available as a witness for any of the reasons mentioned in section 32, the entry would be relevant, and also under that section, it is sufficient to charge any person with liability. Whereas if the person making the entry is available as a witness, it will be relevant under section 34, but its sufficiency would depend on whether it is being used to charge a person with liability or for any other purpose. The fact of the existence of the entries in the accounts book is relevant under section 34, but the fact that there are no entries regarding the transaction is not relevant under this section. However, they have been held to be relevant under section 9, supporting or rebutting an inference, and section 11, which is inconsistent with or renders highly probable or improbable any fact in issue or relevant fact. Under section 35, an entry made in public record is itself a relevant fact if the following conditions are fulfilled. The entry must relate to fact in issue or relevant fact. It must have been made in any public or official book, register or record. It must have been made by a public servant in discharge of his official duty or by any other person in performance of a duty specially imposed by the law of the country in which such book, register or record is kept. This section also is an exception to the hearsay rule, and like all other exceptions, section 35 is based on a justification. The principle of this section is that where something is recorded in a public or official book by a public servant or official in discharge of official duty or legal duty, trust and confidence can be reposed on the accuracy of the entries in the record because they are made by a responsible person and in a record which is subject to discipline and public scrutiny. Another reason for reliance on public records is that they are not accessible to or amenable to be made by private persons. Entries in the registers of births, deaths, and marriages, and entries in the municipal revenue registers would come under this section. In the case of a first information report, the section applies to it but only to prove the contents and not to prove the truth of the contents. The reason is that the section contemplates entries being made as a result of inquiry and knowledge of the person making the entry. In the case of the first information report, all that is there is someone giving the police some information and the police recording it. The contents are not checked. To the extent that such information was given, it would be relevant, but no more, unless it forms part of the same transaction or conduct of a victim, in which case it would be relevant under section 6 or 8 of the Act. Regarding relevancy of maps, charts and plans, under section 36, statements made in maps or charts which are generally offered for public sale or made in maps or plans made under the authority of the central government or the state government are relevant. The section deals with two categories of documents: published maps or charts generally offered for public sale and maps or plans made under the authority of the government. The first category derives its justification from accessibility to the public scrutiny and the possibility of exposure and criticism of errors. The second category gets its reliability from the authenticity of its source, that is the government. With regard to the first category of maps or charts generally offered for public sale, relevant under section 36, section 87 of the Act provides for presumption of fact with regard to maps and charts. The presumption applies only to the author, time and place of publication of maps and charts, but not to their accuracy, as their source may be private only and not government. With regard to the second category, section 83 of the Evidence Act provides for a rebuttable presumption of law. The section applies the presumption to two matters: maps and plans were in fact made by the government and that they were accurate. However, where the maps or plans are made by the government for the purpose of any cause, say for a particular litigation between the government and another person, the accuracy of the plan has to be established by the government by independent evidence and it will not be presumed. Under section 37, when the court has to form an opinion as to the existence of any fact of public nature, any statement of it contained in any central or state act or in a government gazette or notification is relevant. Facts of public nature include such facts as that there are civil riots or hostility with border tribes or that there is a state of war between countries. The section deals with the existence of facts of public nature contained in the act and government notification, but not with proof of those acts. Such facts might relate to whether certain areas are declared as disturbed areas or whether certain classes are declared as backward or as minorities in an Indian state, etc. Section 38 deals with proof of foreign law. Under section 38, when a court has to form an opinion as to the law of any foreign country, any statement of such law contained in a book purporting to be printed or published under the authority of such foreign country and contains any such law, and any report of the ruling of the courts of such foreign countries contained in a book purporting to be a report of such rulings is relevant. Indian courts are capable of taking judicial notice of Indian law without requiring any proof, but such judicial notice cannot be taken in respect of foreign law, and it has to be proved before the court. For the purpose of proving foreign law, it is necessary either to produce the book containing such foreign law purporting to be printed and published under the authority of the government of such foreign country, or to call an expert who is well versed in such foreign law. Similarly, for the purpose of proving the rulings of the courts of foreign countries, it is necessary to produce books which contain the rulings of the courts of the foreign countries concerned, which are usually printed in law reports. Now, in order to understand the true nature of a statement and to know in what context and under what circumstances it was made, it is necessary to read the complete statement, as reading only a part of it may lead to erroneous conclusions. When any statement of which evidence is given forms part of a longer statement, conversation, book, document, or a series of letters or papers, a question would arise as to how much of the statement, conversation, etc. would be admissible. Under section 39, the court has the discretion to permit evidence of only so much of the statement, conversation, document, book, or a series of letters or papers as, in the opinion of the court, is necessary for understanding the nature and effect of such statement, and no more. This is merely a rule of common sense and convenience. To admit only isolated portions pulled out of context would not be conducive to justice, as a different meaning not intended may be given to the passage. But at the same time, to read the whole would be a mere waste of time, and hence this discretion is given to the court under section 39. Therefore, the purpose of this section is to avoid wastage of time and effort of the court in perusing unnecessary and irrelevant parts of statements. This is about the relevancy of statements made under special circumstances under sections 34 to 39 of the Act. Thank you.